And here we go with the test of the Friday video, going to see if Camtasia will work and how well the microphone performs. Here we are with the Friday video for Friday, July 21st. And of course, we will have a Wednesday video before the exam, which will go out Thursday at noon and be due back Friday at noon. We'll start with Access. Student wrote a blog entry talking about the apocryphal story of the scientist who was working on a project, took a vacation, came back from his project, went to find his notebooks. They were not in his lab. He panicked. He wondered what happened to them. Eventually, he checked with security, and they said, well, we've locked them in the safe. He then asked for them so he could continue his work, and they said, sorry, we can't give them to you because you don't have a high enough security clearance. Well, the question is, how is the government able to do that? Well, it's to illustrate a point about categories or classes of information and their classification. Now, classification is the process of restricting access to only trusted people. It's used ostensibly to protect valuable secrets. Other times it's used to avoid embarrassment over the actions of governments or government officials. Classifications run from secret all the way up to levels that I can't list. If you have the proper security clearance, you know what levels they are. So let's come back to our scientist at the lab. When you go to work for the government, you're evaluated for a security clearance based upon the work that you do and yourself personally. Government agencies will, when you're hired or when you apply for a new job, will do background checks. And it starts with your personal history. And it's not a personal history that is limited to one page as many of your resumes are. In your personal history, you have to list every place you have lived. You have to give the address. You have to list every place you've worked, who you worked for, who you worked with, who you associated with, and it goes back to when you were a kid. When you list every place that you lived, you also need to talk about associations or memberships in organizations back then. It takes a long time. It can take weeks or even months to be able to go back and reconstruct your life, which is why it's a good reason to keep some sort of record of where you've been and what you've done. So the government looks at what you wrote. They've also been looking at public records about you, arrest records, court records. Sometimes they will look at records about your associations, groups that you belong to. Then investigators take your personal narrative, your personal history, combine that with the records, and they go to verify everything you wrote. Now, this means that they will go, depending upon how sensitive your clearance is going to be, and talk to people where you used to live, people who you used to work with. You'll personally be interviewed, and for some jobs, you'll be given a polygraph exam. Now, you know and I know that polygraph exams are not admissible in criminal cases, but the government relies on them to help keep people honest. And that's classifications. Next blog entry, the exemptions to FOIA. And the student notes there are 9 exemptions, but does that make it a Freedom of Information Act since you have so many ways to deny the public access? Well, FOIA was written, and it has in its preamble the statement that information held and created by the executive branch is presumptively open. In other words, every record, the government starts out with the position that it's available and accessible. Then they came back and wrote exemptions. Now, an exemption merely makes the release of the information discretionary, except for some cases where there's a mandatory non-disclosure rule that applies. But if somebody denies you a record and cites an exemption, well, that exemption is subject to court review and appellate review. And the courts have ruled against the government in any number of cases. You may remember Department of the Air Force versus Rhodes, where a person wanted to access records about a cheating scandal at the Air Force Academy. The government said exemption number 1, national security, national defense. But ultimately the court said, no, that exemption really doesn't apply, and you're going to have to give the records to the requester. Okay, here's one comment from a blog. It's a little confusing. Yes, there are no rights of access under the Constitution. There's no obligation for anybody to talk to you at all. And then I move into the statutes. So what's the difference between a constitutional guarantee of access and a statutory guarantee of access? The First Amendment deals with freedoms, freedom of speech and freedom of press protects us when we write or speak about the government. But that ability, I think you'll agree, does not do us a lot of good if we can't get access to places and information to know what the government is doing to tell our audiences. The majority of the Supreme Court did not agree. In the prison access cases from California and the federal government, a majority of the Supreme Court held that there is no obligation under the First Amendment to provide information, access, or cooperation with the media. I think it was Justice Stewart who said, well, you know, the First Amendment gives the media freedom to be able to say and print what they want, but it's not an amendment that requires the government to help the media out. And that position of the Supreme Court continues to this day. Well, if the First Amendment doesn't guarantee us a right of access, we've had to rely upon statute passed by Congress to give us access, and at the state level, laws passed by state legislatures. The Freedom of Information Act, passed back in 1966, was the most significant law to help hold government accountable. All right. Another blog question, confused about the whole concept of access and exemption number 3. Remember, exemption number 3 is exemption for materials that are exempt from disclosure because of statute. And I cite the case of FAA versus Robertson. It's an outlier case. So, let's go back. An exemption makes the release of a record discretionary. Exemption number 3 says that there are some records that can't be released because of statutes that say you can't give this out. The Atomic Energy Act makes disclosure of records and information about making atomic bombs non-disclosable. Most famously, from the presidential election, once a federal tax return has been submitted to the IRS, the federal government cannot release it. Now, just to let you know, individuals can release their income tax returns anytime they want, and that was a tradition for decades until Donald Trump said, I'm not going to show you my income tax returns. But getting back to exemption number 3 and FAA versus Robertson, remember Robertson was the head of the FAA. Someone requested information or records held by the FAA about the relative safety of airlines. And Mr. Robertson said, I'm not going to give that to you because I don't want to erode public confidence in the airlines that they're flying. Because of that denial, the requester went to courts, and the court said, okay, we're going to apply exemption number 3. There's not a statute that makes these airline records confidential, but because Mr. Robertson has been made the head of the FAA, he's been confirmed by the Senate, that is to say the Congress has given him an okay, we're going to treat his decision as head of the FAA as something that is equal to a law or statute. Now, as I say in the text and also in the lecture, Robertson is an outlier. It's a case where the courts are on the fringes, and I'm thinking that we should not have too many other cases that go that way. But it exists, and we have to understand that. the section on radiation testing. Okay, yes, the government keeps secrets from the public. And the question was about Secretary of Energy Hazel O'Leary. Did she know about this? Did she make a mistake in allowing the documents to be disclosed? What about a disclosure and the threat to national security? Well, let's start with Secretary O'Leary. The radiation testing took place a long time before Secretary O'Leary was the head of the Department of Energy. She was Secretary of Energy in the Clinton administration. The tests were conducted by government officials during the period of the Cold War, which we can say goes back to the late 1940s and through the 60s and 70s and even 80s. Sorry about that. We somehow slipped back a slide. So it was long before Ms. O'Leary was the secretary. Now, reporters had heard rumors about this. They tried to track down stories about this, and for many years had made requests to the Department of Energy. Nobody had released those records. Then, for whatever reasons, I haven't talked to the secretary, I don't know why she did it, she heard about the request made under FOIA, and she directed that the Department of Energy release the records. She was making government accountable by providing more transparency. Now, the question about national security, yes, the radiation tests were secret. In the United States, the government didn't want the Soviets to know what we were doing because some of our tests might suggest tactics and strategies to use in a nuclear war. Now, the Soviets were doing their own tests, and they had pretty much the same data. But it was the Cold War, right? It wasn't a declared war. That's why it was called a Cold War. But we didn't want to give the Soviets any edge in radiation testing, so we made everything confidential. The question then comes up, how much of the secrecy was because the government did not want people to know that we were using poor kids or people in the armed forces or people who were prison inmates in order to conduct these tests? I don't know. But I can tell you that I haven't heard of a whole lot of people coming forward after radiation tests were made public to say, oh yes, I did the testing with these poor kids at the school, or I did the testing at Oak Ridge where we killed the little kid, and I want everybody to know because I'm proud of what I did. So that could account for some of the secrecy. Going back to FOIA, it looks like the exemptions are broad, but more things are covered by FOIA and the presumption of openness. And the student asks, what sort of documents are commonly requested under FOIA? What kinds of documents do reporters often request for stories? Well, reporters, and it's not just reporters, anybody can make a request. And you can make a request under FOIA, or you can make a request under the state open records laws. Although in McBurney, we find that the Supreme Court says you have to be a citizen of the state in order to make a request for particular state records. But getting back to FOIA and public records, I work with reporters, student reporters, professional reporters, and I tell them that the first thing they need to do when they start a story is to ask for public records. Because public records can tell you things that a person in government would never admit publicly. And people ask for anything and everything they can think of that might lead to a story. Now, the next slide, you're going to see some headlines that are based upon stories resulting from records requests. So up here at the top, Mother Jones, an investigative publication. There's a headline, white nationalist gets money from Louisiana cotton fields in the U.S. government. Mother Jones made a request to the Department of Agriculture about Mr. Spencer and any subsidies that he was getting for his cotton crop, and they found out that he was getting money to grow cotton. In Washington, D.C., the Washington Post was looking at suspensions in high schools because it appears that if you're a black student, you're much more likely to be suspended for infractions that a white student uh, wouldn't even be brought into the office for. And they did that by asking for records and finding, based upon the records, how many people were being suspended. Now, high schools, the people in high schools, were not telling folks that they were suspending a lot of people, but they had to make monthly reports. Here's a headline about the presidency and Trump's businesses. There, they took a look at public records, records regarding income. Next one, deep industry ties to Trump's deregulation teams. People on the Trump administration have to fill out disclosure forms about their financial activities. And so reporters requested those and looked those things up. The video shows police trying to explain why they pulled over a Florida state attorney. You may have heard about this a week or so ago, where the state attorney for Florida is driving and the cops pull her over. She is a black woman, and news organizations made public records requests under the Florida public records law, and they got the body cams and dash cam video. And then finally, under state openness laws in Louisiana, they found that while there was debate about taking down Confederate statues and flags, that a lot of people were emailing state lawmakers and saying, no, we want to keep those. We don't want to take them down. And the public records request allowed reporters to see, get an idea of how popular the Confederate statues were, or statues, I should say. Right. Access video, getting access to documents, and the student, of course, has seen the movie Spotlight. If you haven't seen the movie Spotlight, I highly recommend it. It will get your blood going, and it may give you a sense of purpose about what you're doing here in journalism school. And of course, Spotlight was about the Boston Globe investigation of the abuse of minors, children, by priests. The Catholic Church was not eager to share information, so a key part of the investigative series, and the Boston Globe did more than 200 stories about this, were records filed with courts in lawsuits against the church over this abuse. The question is, what kind of qualifications do you need to get permission for legal documents like that? And the qualification is you have to be alive, because court documents are, generally speaking, public. You go down to the courthouse, you go to the clerk's office, and you ask for files. Now, in my public affairs reporting classes, I take the class to the courthouse, I sit them down in front of the public access computer, and there you can type in somebody's name, press the search key, and if there are any cases associated with that name, it comes up on screen. It gives you the case number. Then you can take that case number, go to the clerk's window, and say, I'd like to look at this file. And they're supposed to give it to you. So it's just a matter of taking the initiative. A lot of times students don't try that because, number one, they're not aware of the existence of those records, or number two, it seems so mysterious and challenging that they don't try to do that. But hey, the records are there for you to be able to get, and they can help make stories really much more dynamic. Investigative journalism, what other sorts of things would you be looking for? Please excuse the phone ringing in the background. So, hang on, we'll just kind of hope that this thing ends shortly. And so, just kind of take your time, go get something to eat. All right, we're back. So, what kinds of stories have you written that you need access for? Well, I've covered a lot of things from federal agencies, schools, policing agencies. And so I've looked for records on where the school districts and universities spend money. In one story that I remember, at this one university, the president announced that they were going to spend more than $300,000 to put new AstroTurf into the football stadium. And this was probably 3 weeks after I had written the story where the deans of several colleges were saying that their colleges were in trouble because the university was not giving them enough money to replace broken lab equipment, to buy new lab equipment. The library said we don't have money to buy new books. And then here, less than a month later, the president was talking about spending a whole bunch of money for new AstroTurf for a football team that was at the bottom. It was called University of Texas at El Intercepted Paso. It was UT El Paso, my alma mater, and the football team sucked for a number of years. And so I got access to records to see how much money was being spent on education versus how much money was going to be allocated to the AstroTurf. I've also looked at budgets for policing agencies. Budgets are important because, whether you know it or not, the more important you are, the more money you get to spend when you're covering government. So you always want to look at budgets and see where the money is going, because that shows the priority of the government. I've asked for statistics on arrests. I've also looked at contracts between government agencies and private companies, because there you have the opportunity for corruption or sweetheart deals, where one particular company gets a contract and nobody else does. And it turns out that the company is owned by a relative of a government official. And I've also used records to look into misdeeds by university officials. I've looked at pay for public employees and more. Access to records is really great because you have the record and it's there. It's an official document. It's what the government says happened. And if someone says, no, we're just as pure as the driven snow, we've never done anything bad, well, the record shows something completely different. And it's pretty reliable. People trust those. So it's helpful. It helps us to keep government accountable. All right. Yes, there are 9 exemptions. We really only deal with 7 of them. Question is, will we be provided with the exemption the plaintiff is objecting to, or is that something we'll determine ourselves? So on the exam, you will either be a requester of records, a FOIA officer responding to the request, or a judge sitting in judgment of a denial of records. You're going to be given a fact pattern. You'll have to decide what to do to get a record, what to do to keep someone from getting a record, or being a judge deciding whether a record should be made public or not. So here's a sample question. And you see this thing, students at a middle school in Wisconsin. This is an old story. I didn't pick it just because I'm now living in Wisconsin. But here, kids are getting sick, and they're getting sick because of bad food. And the bad food was provided by, that's not Decorated Tortilleria, it's Delray, which had a history, was associated with any number of cases where kids got sick after they ate the Delray provided tortillas. So in our sample question, I'm telling you, I give you the fact that we've done an internet search and found that Delray is linked to similar outbreaks of illnesses at more than a dozen schools in 2003, 04, 05, and 6. Now I'll update that in the question. Here, this is an old one, we're just going to walk through that. And you'll also see that there's a story that says the Federal Food and Drug Administration, and pardon the interruption by my dog Zuma, you've heard him before. Okay. So, back to the question. You've seen in some news stories that the FDA issued a warning about Delray, saying its tortillas had a potential to cause illnesses. So here are 3 possible questions based upon this fact pattern. One is you as a requester. So the question is, you want to do a story to see just what the FDA knows about Delray. How do you get the information you need? And there you would walk through the process of getting information through a FOIA request. The second variation in the question, a second question entirely, is you become an FDA FOIA officer and you don't want to release the information about the FDA investigations into Del Rey. So the question is, how do you keep the information from the snoopy reporter? In question 2, in version 2 of the question, you see that you are going to have to look at exemptions and see if you can pull some out of the 7 that we use to justify keeping the records from the reporter. And then the third version of the question, you're a judge, your reporter's requested records, the FDA has denied the request and they cited exemptions 4 and 6. And so your question is, do you rule for the reporter or Del Rey? Now here in version 3 of the question, you have 2 exemptions that the FDA has cited. And so you're going to have to analyze the exemptions, apply them to the facts and say, well, yes, this looks like a proper application of the exemption, or you're going to say, no, this exemption does not apply. Therefore, the requester is entitled to the records. So, just an idea about what you have to do for access. Now, understand that this is not one of the questions I pulled from the test bank. It's one that I was toying around with for a number of years ago and ran into it when I was looking through my files. But it gives you a general idea. When I ask questions on the third exam, sometimes the question will be FOIA, other times it'll be California Public Records Act. And you'll have enough information to use the correct statute. So in question 2, right, the one where you're the FDA FOIA officer and you don't want to give the information, you have to say, I will cite these exemptions and this is why this exemption applies and this is why the reporter doesn't get the information. And then, okay, typo, in question 3, the bottom bullet point, you'll have to judge the use of the exemption and then rule correctly on who you think is right, either the reporter requester or the FDA official. Here's a question. Once you file a request and the company or organization has 20 days, if you question denial, then can they claim an exemption? Well, it wouldn't be a company because companies are not part of the federal executive. And if you make a request to a federal executive agency and they deny the request, the denial has to cite the exemption. Because when they created FOIA, they said it's going to take long enough. So, when you turn them down, you have to tell them why so they can decide if they want to appeal or just take you to court. Otherwise, you'd make the request, it would not be denied, you'd then have to make a request for what the denial was, and here we are, 10 years later, and there's no interest in the subject of the story anymore. Okay, California Public Records Act. And the Access video has Q&A about CPRA. Well, there's not another CPRA lecture. Understand that CPRA is similar to FOIA. It just applies to California. You now have, because I sent it out to you, an edited copy of CPRA so you can go through the exemptions on the test to determine whether the requester should get the record or not, and whether an exemption was properly administered. It's really pretty easy. And in fact, for CPRA, as well as pretty much all state open records laws, they have, because FOIA predates them, at least most of them, they have often said that FOIA is the model that we use. So when they have an issue, a lot of times they will look at the cases involving FOIA requests and see what the judges ruled there, and then apply that to the state requests. So keep that in mind. CPRA, state, FOIA, federal. And you have the exemptions, and I've given you an abbreviated list of exemptions so that it doesn't overwhelm you, you'll have enough to be able to answer questions on the test, depending upon what comes out of the test bank. Okay, so CPRA. Now, you'll notice that CPRA refers to the public interest balancing tests. There are certain things that state laws say you can't give out, like addresses for police officers or members of the assembly. Other things it says you balance the public interest versus the interest in keeping it confidential. So here's an example. CPRA, just like FOIA, lays out records that are not to be given out. You just have to see if the state body claiming an exemption is doing so properly. So if someone wanted to ask how much Armstrong makes a year from Cal Poly, and the university says it won't because of section 6254, and here's a parenthetical. Section 6254 runs on until you get to section 6255. So subsection 6254.21, section 6254.3, all of those are part of 6254. So keep that in mind. Oh, and of course, 6255, very important section because that's the balancing test section of CPRA, where it says you balance the public interest versus the interest in non-disclosure. Privacy Act of 1974, and the question is, or the statement is, I'm surprised that there wasn't one before 1974. And the student makes the observation that it's something that the student thinks should have been implemented a lot earlier in history. Well, you have to understand the context, because the Privacy Act of 1974 came about following revelations about domestic spying on Vietnam anti-war protesters. Many laws were broken by the CIA because the CIA was operating inside the United States, and the charter of the CIA says, no, you can only do things for it. Military investigators were looking at anti-war protesters when the military cannot do civilian law enforcement. Federal law enforcement agencies violated the laws. Now, when they did this, people said, what information have they gathered about folks, and is it correct or not? We should give people the opportunity to find out what the government knows about them, and the opportunity to have the government correct anything that's wrong. So Congress passed that law. Now, you'll note when we went through the Privacy Act that it exempts law enforcement, national security. So it seems that it's not as helpful as you might think. But they had to put those in place. If they didn't put those in place, if you're committing crimes, you might just make a request and ask, what does the government know about me, and do they know about my meth lab? And then if the government was forced to tell you, they said, oh, they know about me, and they have a confidential informant. I'm going to find the person and kill them and be safe in my criminal enterprise. So there are reasonable reasons why the Privacy Act doesn't give access to everything. Now, the reason it took until 1974 for us to have something like this is because nobody knew the government was doing these bad things. Well, during the anti-war protests, people were saying, I think the government is spying on me. But not a lot of people took them seriously. It was only after the Select Committee on Intelligence held its hearings that people said, oh my God, the government is spying on Americans. And it was that disclosure, that revelation, that prompted Congress to pass the Privacy Act. Now, students today, are not as surprised because we know, thanks to Edward Snowden, that the government is looking at us more than ever. And in a lot of cases, we're helping the government out by the way we conduct ourselves electronically. Here's a question from a student who was in my 203 class. And the student was doing a story on financing and donations for the meal voucher program. Now, meal voucher program is one that was put into place a couple of years ago. It said if you're a student and you don't have enough money for food, you can go see somebody on campus. Actually, they have like 5 places you can go, and they'll give you a voucher which you can use to buy food and not starve while you're trying to go to school. The head of student affairs, I think it was, didn't want to provide information about how much money was in the program, who was giving money to the program. And of course, I told the student, look, this is public information. It should be public under the California Public Records Act. Now, the student managed to put together a story. We didn't actually need to sue the university, but if we had needed the information, we would have filed a CPRA request, not a FOIA claim, because CPRA applies to California and FOIA to the federal executive. All right, we'll move on to free press, fair trial and post-September 11th. And the question is, the government detained an undisclosed number of persons in secret locations, close to the public and press. How is this legal? Well, it's legal because people were panicking. People were very afraid. September 11th was a shock to the nation. We'd never been attacked at home. Yes, we were attacked at Pearl Harbor, but at the time, Hawaii was not even a state, and it was thousands of miles away across the Pacific. There had been the World Trade Center bombing, car bomb, but it wasn't a big deal. Here, hijackers took control of 4 airliners and in 3 cases crashed them into buildings, and in the 4th case wound up crashing into a field in Pennsylvania because the passengers fought back. But there were fears that more attacks would take place. We've been hit by these attackers. Who's to say that they don't have more attackers waiting to get us? And you have to keep in mind that non-military flights, there was nothing flying in the days after 9/11. I remember because I was living in Oklahoma, and one of the things was we were kind of near one of the flight patterns for the Oklahoma City International Airport. And in the days after 9/11, in fact, on 9/11, I went outside and I said, geez, something's different, something's strange. My wife came out and said, yeah, you can't hear any planes. And there were no civil aviation or private planes flying, there were no airlines flying, because we were afraid that hijackers would attack us yet again. Now, the attackers were associated with Al Qaeda. All but one were from Saudi Arabia. Al Qaeda, led by Osama bin Laden, really came into being during the Soviet occupation of Afghanistan. He was one of the Mujahideen fighting the Soviet occupation, and we liked him. We provided support to him. Then the Soviets left Afghanistan. It was really great. The Muslim freedom fighters defeated them. But then Osama bin Laden said, why are Americans in Saudi Arabia? Saudi Arabia, of course, the place where the holiest sites in Islam are. And Osama bin Laden said, these persons who are not Muslim from America, they should not be in Saudi Arabia. They are defiling our sites simply by being there. Of course, the United States has supported Israel. And so Osama bin Laden said, well, we've defeated the Soviets, now let's defeat the Americans. He was Muslim. So after 9/11, the government said, let's round up everybody from the Middle East, let's especially get Muslims. And it was done without a lot of public attention. Now, done without a lot of public attention because people would disappear. And they couldn't call a lawyer, and they couldn't call family members. They couldn't tell them, hey, I've been detained by the government, because they were locked up. They had no way to communicate with anybody. And the government wasn't telling the media that, oh, we're arresting a bunch of people, thousands, because they wanted to keep it secret. And the government said, the 9/11 attacks were carried out by a cell of attackers. Now, a cell is a group of plotters living in a country who are going to engage in terrorism. The government said, we're afraid that there may be other cells, so we're going to round everybody up so we can find any more Al-Qaeda people and prevent any other attacks from occurring. Now, as is always the case, most of the people who were rounded up were simply caught in this big net thrown out by the government. They were held in secret. They couldn't contact their families. No, the government wouldn't allow their families to be notified about their detention. They were not allowed to contact lawyers. Nobody knew who had been detained apart from, hey, there are some people we haven't seen lately. What happened? The ACLU sued, news organizations sued to gain access to the detainees and were denied by trial courts. News organizations appealed to the Sixth Circuit Court of Appeals and the Third Circuit. At the appellate court level, the government argued that information about detainees should be kept secret and argued the mosaic theory. Now, this leads to another comment and question. The student was interested in the mosaic concept. One piece of information may be the final piece of a puzzle for somebody somewhere. How does mosaic work in court? What does it mean for the government to have invoked mosaic? So what is it? All right, so let's go back to art class in public school. You may have made mosaics when you were taking an art class. It's a piece of art in which small pieces of tile are arranged in a pattern that, when you step back, creates a picture. The government said in the Third Circuit and the Sixth Circuit Court of Appeals hearings that releasing information about any single person who had been detained would be like giving Al-Qaeda individual pieces. If Al-Qaeda and Osama bin Laden got enough pieces, they could tell how many cells were still operating in America and how many terrorists were still at large and able to conduct another attack. Now, there were no other attacks by other cells. And intelligence analysis said Al-Qaeda was fortunate. They caught lucky breaks in having the 22 attackers carry out the attacks. But they didn't have a whole network across the country. And that was the argument. Now, mosaic is at the beginning of free press fair trial, but it's not in the sections on closing trials or pre-trials, because it doesn't deal with trials. It prevents people from even knowing if anybody's been detained and might face prosecution. It's been invoked in terrorism and more often in gang cases where people say, we don't want the gangs to know that we've arrested somebody in the gang because if they know somebody was arrested, they'll figure somebody must have informed and they'll kill witnesses. In fact, that's how secret criminal trials are happening more than the war on terrorism. And another blog about the detainees. The Supreme Court refused to hear the two cases in the Third and Sixth Courts of Appeals. And a very, very good question about midway in the paragraph. Doesn't this mean that the Sixth Circuit could require access and the Third Circuit could deny access? If that's the case, the government could deny access by moving cases into the Third Circuit. Doesn't this just give them an avenue to avoid granting access to the public? This seems backward to me, so I want to be sure I'm understanding what happened correctly. Well, you're absolutely correct. The Sixth Circuit said the requests from the media and the ACLU and members of the public must be granted. You have to tell them about detainees. Third Circuit, of course, said, no, we're going to trust the government. You can't ask for anything, and they don't have to tell you anything. And so what that meant was that the government moved detainees from the geographic territory of the Sixth Circuit into the Third Circuit so that none of the cases would go to the Sixth Circuit. They would wind up staying in the Third Circuit Court of Appeal jurisdiction, and the Third Circuit had already backed the federal government. So it was by design that once they had the win in the Third Circuit and the loss in the Sixth Circuit, they just made sure that all the cases had to be brought in the Third Circuit. And related to that, don't the higher circuit courts have more to say in the judgment of a case? If the Sixth Circuit Court ruled for access, shouldn't the Third Circuit courts abide by that standard? And the answer is no. There are 13 circuits, 12 circuits, and the DC Circuit. Each circuit has control over a geographic area. So the Ninth Circuit, our circuit, covers California, Alaska, Arizona, and Hawaii. And that's all it covers. It doesn't cover New Jersey or New Mexico. It only covers those 4 states. The Third Circuit and the Sixth Circuit both have separate geographic coverage. They don't overlap. Now, each Circuit Court of Appeal is equal in power to every other Circuit Court of Appeal. And they have been described by legal scholars as laboratories, where if you have a controversy, then the case can be tried in one circuit and heard by the Circuit Court of Appeal, and they can analyze the case one way. And if the same sort of issue occurs in a different state, then a different Circuit Court of Appeals could look at the case and come up with a different rule, so that by the time the Supreme Court is ready to look, they have had different Circuit Courts of Appeal go through the arguments and go through the analysis, and they can pick the one they think is most appropriate if they decide to take the case. So, in the Sixth Circuit Court of Appeal, every federal court within the boundaries of the Sixth Circuit Court of Appeal are bound by the Sixth Circuit opinion. The Sixth Circuit says the information has to be disclosed. The Third Circuit sided with the government and held the information should still be kept confidential. So, just as the Sixth Circuit can't make federal courts in the Third Circuit open up, the Third Circuit can't make courts in the Sixth Circuit shut down. So we had 2 directly opposing rulings from 2 different circuit courts. The Supreme Court decided not to take the case. So what that meant is they said, okay, in the Sixth Circuit it has to be open, in the Third Circuit it can be closed. And of course that meant that the government would move everybody to the Third Circuit so that the rulings would go in their favor. The Supreme Court sometimes does not exercise its moral power. Sometimes the Supreme Court just says, no, it's not right, it's not time. The issue isn't right for us to decide. And so they waited. Well, it's kind of like, how long ago did the Supreme Court rule on marriage equality? There had been challenges to laws that denied marriage rights to same-gender couples. They had been made in state courts, they'd been made in federal courts, and the Supreme Court, in the years when that was happening, said, no, we're not going to take this case. So the Supreme Court bides its time and waits. But they get to, because they are the highest court in the land. Continuing with free press fair trial, cases being overturned, how does overturning work? If the case is overturned because of pre-trial publicity, what does it mean? Is it like a mistrial? Surely it isn't a dismissal. It's not a dismissal. All right. For any case, the case has been tried. There's a judgment. One side wins, the other side loses. The losing side can appeal. The appeal is based upon an argument that the losing side lost because the judge made a mistake. Usually the mistake deals with evidence. Did the judge improperly admit evidence that shouldn't have been admitted, or did the judge improperly exclude evidence that should have been admitted? For us, it is, did the judge improperly apply the First Amendment? Now, the losing party appeals, it goes to the next higher level. The next higher level looks and says, well, okay, the judge made a mistake, or the judge didn't. If the higher court says the judge didn't make a mistake, that's it. If the appellate court says the judge did make a mistake, the appellate court says, well, was this harmless error or was this reversible error? If the appellate court says it's harmless error, then the appellate court is saying, yes, the judge made a mistake, but it was a small mistake. It didn't change the outcome of the trial. It didn't deny the party a fair trial. But if the appellate court says it was a reversible error, that means the mistake the trial judge made was substantial enough that the judgment will be reversed because the mistake meant that the losing party didn't get a fair trial. Now, what that does is, for criminal cases, the conviction is wiped out. For civil cases, the judgment is wiped out. If a prosecutor wants to try a case again, he can, because when you successfully appeal a conviction, then it means no trial was finished. So you may hear the term double jeopardy, which is you can't try someone twice for the same offense. And students, because it was a more popular term years ago, used to say, well, isn't it double jeopardy if you have an appeal and the appellate court overturns the conviction? How can you try this person again? You can do so because the first case now is treated as if it never happened. Getting back to free press for a trial, if there was so much publicity, or if the publicity was bad enough that the members of the jury wound up judging the case based upon what they saw about the case in the media, in other words, the story they saw in the newspaper or on TV or online, that's why they voted to convict the person. Well, that's not proper. Cases must be judged solely on the basis of credible evidence produced through the witness stand. So if a jury member votes a particular way, not based on the evidence, but based upon something they saw in the media, the defendant did not get a fair trial. And if the defendant did not get a fair trial, then the appellate court is supposed to overturn the conviction, make them retry the case with a different jury made up of people who haven't been affected by this publicity. What exactly is a prosecutor? Who do they represent? It's a fair question. Prosecutors are in criminal cases. Prosecutor represents the state. In civil cases, we have the plaintiff's attorney and the defense attorney. In criminal cases, we have the prosecutor and the defense attorney. So that's who it is. Question about the Watson Declaration. All right, this goes back to the detainees. The Watson Declaration was a declaration that was made, in other words, it was a sworn statement by the FBI's head of counterterrorism, who said, if you tell people about who's in detention, Osama bin Laden and Al-Qaeda will know who is still out there and they'll be able to coordinate attacks. And the question is this something to be used on the test? No. The Watson Declaration will have no relevance to any questions on the test. Similarly, the mosaic, sorry about the misspelling, the mosaic theory will not be relevant because we're not going to have any detainee questions on the test. That's for advanced law school students. And of course, popular media comes into it. There was a television show. The plaintiff was trying to prove the defense was bribing a juror. That meant that a substitute juror was brought in to replace the person who might have been bribed. Of course, at the end of the case, the plaintiff won, but the plaintiff's attorney found out that the client bribed a different jury and tried to cover it up to make it look like somebody else was being bribed. The attorney for the plaintiff wanted to do something to bring the client's dishonesty to light, but her firm refused. Is that even possible for an attorney to appeal the case? Well, the short answer is it was a television show. And television shows are not real. But the longer answer, and actually it was a good question. Every question is a good question. The canons of ethics require that lawyers bring to the court's attention any violation of legal ethics, such as jury tampering. It's also a crime. It's a felony. And a failure to disclose a felony is a felony in and of itself. It's called misprision of a felony. Don't bother trying to look it up because it's not something we'll deal with. But yes, the canons of ethics require this. When I was in law school, we spent an entire semester on professional responsibility, which was what are lawyers supposed to do and what are the things that lawyers are not supposed to do. And for the bar exam, there's the bar exam, and a lot of states also require the MPRI, that's the Multi-State Professional Responsibility exam. So yeah, no, it's a legitimate question. In TV and even in the movies, they don't follow the law because they want to take artistic license and make a better story. That's the last of the questions. The pretest video, based upon the questions you send me from today and through Tuesday, will go out Wednesday. The third exam will go out Thursday at noon, be due back Friday at noon. So send me in your questions so that I can, with any luck, make it clear before you take